Hello and a warm welcome to Well This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notification for new videos. My name is Sheetal June, Associate Editor, latestlaws.com, and let's begin with Supreme Court this week. This week, the Supreme Court held that psychological evaluation in criminal cases is a material piece of evidence and recognized that even though psychological evaluation alone may not be sufficient to secure a conviction, it holds significant evidentiary value and cannot be disregarded. The Division Bench of Justice Abhay S. Oka and Justice Rajesh Bindal observed that although the psychological evaluation alone may not be sufficient to convict an accused, it holds significant evidentiary value, and despite the presence of such evidence in the record, the High Court wrongly concluded that the case did not warrant framing charges, even though only a prima facie case needed to be established at that stage. The court highlighted that the High Court selectively referenced certain statements recorded during the investigation, thereby displaying a lack of meticulous examination and evaluation. The selective approach demonstrated a failure to fully grasp the depth and scope of the evidence, which in turn hindered the High Court's ability to make a fair and informed decision, the court said. The Supreme Court has observed that a writ court should restrain itself from imposing its decision over the decision of the employer as to whether or not accept the bid of a tenderer unless something very gross or palpable is pointed out. The three-judge bench of CJI D.Y. Chandrachud, Justice J.B. Parthiwala and Justice P.S. Narasimha stated that the court, being the guardian of the fundamental rights, is duty-bound to interfere when there is arbitrariness, irrationality, malefides and biases. However, it should restrain itself a lot while exercising these powers of judicial review in contractual or commercial matters. One must remember that today only public sector undertakings compete with private industry, and that the contracts entered into between parties are not subject to scrutiny under a jurisdiction, the court said. No doubt the bodies which are state within the meaning of Article 12 of the Constitution are bound to act fairly and amenable to the jurisdiction of the superior courts, but this discretionary power must be exercised with a great deal of restraint and caution, it added. The Supreme Court has opined that a contract entered into the name of the President of India cannot and will not create immunity against the application of any statutory prescription imposing condition on parties to an agreement when the government chooses to interfere into a contract. The court reiterated that Article 299(1) of the Constitution requires a specific procedure for government agents to enter into contracts that bind the government and prevent unauthorized or illegitimate contracts. Consequently, contracts not meeting the form prescribed by Article 299(1) cannot be enforced by any party. The court observed that Article 299 solely addresses the formal requirements of government contractual obligations and does not encompasses the substantive laws governing the government's contractual liability. Therefore, even if a contract is formally valid and under Article 299, it may still fail to bind the government if it is void of unenforceable according to the general provision of the law. The Supreme Court has emphasized that the Consumer Protection Act has commendable objectives to protecting consumer interest and promoting consumerism in the country, and its provisions should be interpreted liberally to fulfill this purpose. The Act aims to protect consumers who would otherwise lack effective remedies under ordinary law and enables consumers to participate directly in the market economy. The provisions of the Act should be construed in favor of the consumers while considering the legislative intent, the court stressed, while clarifying that Section 2B and 12 requires broad and inclusive interpretations. The Section 21 of the Consumer Protection Act establishes the jurisdiction of the Commission based on the value of goods or service and a compensation claimed. For complaints filed under Section 12(1)(c), where numerous consumers with the same interest are involved, all consumers aggregate value of goods and services and compensation claims determine the jurisdiction. The value and compensation claimed by individual consumers are irrelevant to the determination of the jurisdiction in such cases, the court said. Next, we have Delhi High Court. The Delhi High Court has held that subsection 6 of Section 16 of the Maintenance and Welfare of Parents and Senior Citizens Act 2007 places an obligation upon the Appellate Tribunal to pronounce its order in writing within 1 month of the receipt of the appeal. The single-judge bench of Justice Tushar Rao Gadela observed that the tribunal must use all reasonable means to ensure that the provision is carried out in its entirety to the feasible extent. The preamble of the Act explicitly states that Act's sole objective is to prevent seniors and parents who may be at the vulnerable age and stage of life from being unnecessarily deprived of this shelter, it added. The Delhi High Court has held that just because an invention involves computer programs and algorithms, it shouldn't automatically be considered a computer program. Instead, it should be evaluated based on its technical advancements and practical usefulness in solving real-world problems. The single-judge bench of Justice Sanjeev Narula observed that if a computer program is combined with hardware or results in a technical outcome, it could be eligible for a patent. That the addition of per se was intended to clarify that the genuine inventions based on computer programs should not be denied patents. The court was of the view that technical effect and technical advancement when determining the patentability of CRIs should be highly considered. It opined that when considering patent application for computer-based inventions, it is important to consider legal precedents, guidelines for computer-related invention, and the legislative framework. If the invention provides a technical benefit or solves a technical problem, it may still be eligible for patent protection even if it involves mathematical or computer-based methods. In other words, a computer program patent may be granted if it results in technical advancement and solves a technical problem, improving the underlying software. It further opined that the controller's approach to rejecting a patent application was misguided because they only considered whether the invention involved computer algorithms and instructions. Issuing a slew of guidelines to be followed by the mediators while drafting settlement agreements in the matrimonial disputes, the Delhi High Court has asked to publish such agreements in Hindi as well in addition to English. The single-judge bench of Justice Swarna Kanta Sharma observed that a common understanding of the parties on essential conditions for the enforceability of an agreement is crucial in a mediated settlement agreement, and expressing intentions and commitments to the agreement through clear and concise language is critical for its effective enforcement. The court opined that the dispute in question has arisen primarily due to an inadequately worded and ambiguous mediated settlement agreement. The primary objective of mediation in matrimonial cases is to facilitate early resolution of disputes outside the court remarked. The court was of the view that there is an urgent need to ensure that agreement drafted to settle the issue to bring an end to a future or pending list does not itself become a matter of dispute giving rise to another list between the parties. Since mediated settlements agreements are usually drafted in English, the court pointed out that it is important to carefully draft and ensure that the parties concerned comprehend the agreement in vernacular languages as it can significantly impact its effectiveness and execution. Assuming that the majority of the litigants who approach courts in Delhi speak Hindi as their first language, the court directed for the drafting of the settlement agreements in Hindi as well. The court hoped that once the agreements are written in Hindi wherever required, which is the parties understand, and the mediator performs his or her duty carefully, it will ensure not only the finality of the agreement in the mediation centers but also its successful culmination in the courts of law, which is the aim and objective of the mediation centers. The court concluded that the lives of people embroiled in matrimonial litigation are often in stage of turmoil, and thus the mediation as a method of alternate dispute resolution has to come to their rescue instead of further extending the state of turmoil. The Delhi High Court has said that right to own a firearm is not a fundamental right in India. The court made the observation while hearing an advocate's petition against the Delhi LG's decision rejecting his application seeking an arm license. All lawyers and advocates who are appearing on the criminal side of the accused or the prosecution cannot claim a right to own an arm license in as much as this could result in issuance of arm license indiscriminately. The perceived weakness of the state, which is one of the grounds which the petitioner has urged for seeking the arms license, if accepted, would result in recognition of a right to own a firearm. The recognition leading to issuance of a license and unbridled owning of the firearms could also pose a threat to the safety and security of the other citizens, which the licensing authority would have to keep in mind while allowing and or rejecting the arms license, the court said. Now let's have an overview of other high courts. Allahabad High Court has stated that a husband cannot be called as an accused for violation under Section 138 of the Negotiable Instrument Act if his wife, who is the sole proprietor of a business, issues the check. The court noted that the applicant's wife issued the check and that the applicant did not act as the authorized signatory, agent or guarantor. In the eye of law, the wife and husband have separate entities. It is not a case that the wife, sole proprietor of the firm, had provided the check signatory signed by or on the behalf of the applicant. Therefore, the court concluded that the applicant, being the husband of the sole proprietor of the firm, cannot be summoned under Section 138 of the NI Act as an accused. The Bombay High Court has ruled that an amendment to a complaint can be made to remove a curable infirmity or defect as long as it does not change the basic core, crux and tenor of the complaint or nor cause prejudice to the other party. However, when the amendment involves adding a company or firm as a principal offender, it cannot be allowed as the criminal court takes cognizance of the offence, not the offender. If the check is drawn on the account of the company or the firm, then the principal offender is the company or the firm, and the prosecution against directors or partners cannot be maintained if the company or the firm is not party to the complaint. Therefore, an application to add a company or a firm as a party to the complaint to remove such a defect cannot be entertained. The Gujarat High Court has held that there was a lack of essential facts and evidence to support the assessing officer's decision to reopen the assessment. A division bench comprising of Justice N.V. Anjaria and Devan M. Desai in a petition filed under Article 226 of the Constitution observed that if the basic facts were not present, then there was no basis to request a reassessment. The court was of the view that neither there existed fundamental facts nor it could be said that any tangible material was available with the assessing officer to justify the exercise of power. Further, the basis of the reopening was absent. When the foundation was missing, that there could not have been an erection of ground to the seeking reopening of the assessment. It could not be said that in fact of the case that the assessment officer could have harbored a reason to believe it accepted in the eye of law to seek reopening. The Allahabad High Court analysed Section 2B of the Uttar Pradesh Gangsters and Anti-Social Activities Prevention Act 1986 and observed that the violence in one form or another is not a sine qua non precondition for a group of a person to qualify as a gang. The single judge bench of Justice J.J. Munir remarked that the twin object of disturbing public order or gaining any temporal precautionary advantage, etc., may be achieved through the practice of violence, threat or show of violence, or intimidation or coercion of otherwise. The court observed that the violence or disturbance of public order is not the only factor that defines a gang under the Act of 1986. A group of people who use violence, threat, intimidation, coercion, or any other means to disturb public order or gain undue advantage can qualify as a gang. The word or otherwise are not to be read in enjusum generis with the preceding words and suggest that the group may act in any manner to achieve the object of disturbing public order or gaining undue advantage. The court did not find merit in the submission that the violence is a sine qua non for a group to be considered a gang. It was observed that the group of people can have two alternate objectives to qualify as a gang: disturbance of public order or gaining any undue temporal precautionary material or other advantage for themselves or others. Moving on to miscellaneous news. Delhi High Court Judge Justice Tara Bitsata Ganju in a recent remark has reflected on the changed perception about women lawyers in the legal fraternity over the decades. She said that earlier it used to be the thing that women lawyers appear before courts only to seek passovers and adjournments and wrap practice by 4:30 p.m. but that has changed now. The judge, who was speaking along with Justice Mini Pushkarna and Justice Manmeet Preetham Singh Arora on the topic Discussion on Enhancing Advocacy Skills, Judges' Perspective, organized by Delhi High Court Women Lawyers Forum, emphasized that the women lawyers are perfectly capable of achieving work-life balance. Justice Pushkarna, who also shared the same sentiment, further added that the women have unlocked new heights in the terms of being thorough professionals. Observing that as per rules, engaging in sex work is not in itself an offence, but to do it in public places so as to cause annoyance to others can be called as an offence, a Mumbai Session Court has directed a shelter home to set at liberty a 34-year-old female sex worker who was taken into custody after a raid was conducted. The woman moved the Session Court after the magistrate's court order had directed that her to be detained at the home for the period of 1 year for care, protection and shelter. Quashing this order, a session court said that under Article 19 of the Constitution, the right to move freely throughout and reside and settle in any part of the territory of India are fundamental rights. The National Company Law Appellate Tribunal (NCLAT) has upheld the insolvency proceedings against cash-strapped airlines Go First in what seems to be a big blow for aircraft lessors who had challenged the decision. Aircraft lessors had approached the NCLAT and challenged the National Company Law Tribunal's ruling that granted bankruptcy protection to the Go First. This means Go First aircraft lessors, which include big names such as GY Aviation Lease, SFV Aircraft Holdings and SMBC Aviation Capital, among others, will not be able to repossess lease. The lessors had earlier said that the airline was using its bankruptcy plea to hold on to planes that it does not own. In fact, SMBC had questioned why Go First had filed for insolvency even with 26 functional aircraft. The global aircraft leasing giant said Go First owes it roughly rupees 700 to 800 crore. While delivering judgment in All India Judges Association versus Union of India and others, the Supreme Court acknowledged the significance of district judiciary and directed that it should no longer be referred to as subordinate judiciary. A bench headed by CJ D.Y. Chandrachud and also comprising of Justice V. Ramasubramanian and P.S. Narasimha delivered verdict regarding the increased salary structure for judicial officers as outlined by the Second National Judicial Pay Commission. The court further called the district judiciary as the backbone of the judiciary and added that to secure their impartiality, it is important to ensure their financial security and economic independence. The court observed that the practice of calling district judiciary as subordinate is not only misnomer but disrespectful as well. Bar Council of India Chairman Mr. Manan Kumar Mishra, who participated in the panel discussion at IDRC's second Arbitrate in India conclave, has announced the plan to introduce rules concerning mandatory continuous learning program for lawyers. When Mr. Ratan Singh took the opportunity to pose before the BCI chairman a suggestion to introduce training program for lawyers and advocates on a mandatory basis and highly urged him to take it with all seriousness, much to his assurance, the latter revealed that following the footsteps of some foreign countries, the BCI is in process to frame rules on the mandatory continuous learning program for lawyers and advocates. He told that in the course of 5 years, at least 40 days, every lawyer will have to undergo some compulsory training and only then their license will be renewed. The BCI chairman also added that the council suspects that this move will be met with an adverse reaction, but they will implement it for the betterment of the legal fraternity and profession in this year itself. In the end, we have international news. The legislature of Taiwan has successfully approved a bill that enables same-sex couple to jointly adopt a child who is unrelated to either of them, marking a significant milestone in their journey towards complete marriage equality. In 2019, Taiwan made history by becoming the first jurisdiction in Asia to legalize same-sex marriage. However, at that time, it did not extend fully equal rights of adoption to same-sex couples, stopping short of granting them the privilege. Prior to the recent legislative changes, adoption rights in Taiwan were limited to heterosexual couples and only single individuals who sought to adopt a child unrelated to them biologically. This created a situation where if a same-sex couple wished to adopt, only one of them could legally register as the child's parent, even if both individuals share the responsibility and duties of raising the child. A boss wrote excess in official email and one of his employees sued him for sexual harassment on the basis of that, quote, offensive mail. Karina, who was an IT worker and a project manager at the London office in a company that provides paperless trade solutions, sued her boss for these emails and took the firm to the employment tribunal, claiming sexual harassment, discrimination and unfair dismissal. She said before the tribunal's judges that she believed her boss had yelled at her because he wanted a sexual relationship and she had rejected his advances. However, the employment tribunal at London Central Court determined that Karina's perception of the event was skewed after hearing the entire case and reviewing the evidence she provided. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.